Happy 4th of July from Fired Up. I'm your host for the show, Bob Irwin, broadcasting from Rigel Studios here in Las Vegas, Nevada. This show is about guns, related political issues, and self-defense. Fired Up is on our website, firedupwithbobirwin.com. A new show is posted every Thursday at 5 p.m. Pacific Time. The show also appears on YouTube and numerous other media. The audio feed is rebroadcast for radio listeners on Saturdays at noon on the Nevada Talk Network. You can find them at KELY1230.com and find the station in your area. You have questions or comments, you can send an email to bob@firedupmail.com or leave a message on my office recorder, which is 702-257-1060. If you leave contact information, obviously, we will respond to that. There are several hundred defensive uses of firearms every week in the United States, rarely covered by any mainstream media, so we always present those for our listeners' education. Most are good shootings, some are questionable, but all are educational for firearms owners. Individual instances generally are adjudicated under local law, so the reminder here is the advice might not apply to listeners in different jurisdictions. Incidents are reported as they happened, except the names are generally omitted. My guest today is California and Nevada attorney Donald J. Green. Don, if you would, a bit of your background.
Again, well, thank you, Bob, and thank you for inviting me for this special 4th of July edition of Fired Up. Bob, for your listeners and viewers who don't know me, my name is Don Green. I'm a staple at most of the gun shows here in Nevada. And we do occasionally talk to people in California at gun shows, but it's very rarely. And the emphasis of my practice is firearms related, both in assisting people in trying to clear up their backgrounds if possible. Also representation of persons and individuals, companies, firearms dealers before the alcohol, tobacco, and firearms. We do checking with the FBI and local jurisdictions concerning background firearms, challenging certain things which may be in your background, and also representing federal firearms dealers in legislation. We have some and litigation, which is possibly coming up. Your viewers and listeners can contact me on my direct cellular at 702-409-8239. And for all your listeners and viewers who call, we do have available now the 2019 kind of an index card, which shows the states which Nevada accepts for the CCW effective July 1st, 2019. Thank you.
All right. This story comes to us from 23 ABC News in Bakersfield, reported on June 21st this year, obviously in Bakersfield, California. A local man attacked a woman with a sledgehammer and a wooden chair during a home invasion earlier this month, according to the documents filed by the Kern County Sheriff's Office on Friday. KCSO say deputies were dispatched to a home near the corner of College Avenue and Montello Street in the morning of June 5th for an active burglary, robbery, and assault with a deadly weapon and child endangerment investigation. Long call for 911. When officers arrived, they discovered a 33-year-old had reportedly forced himself through the home's back door and attacked the female victim with a sledgehammer and a wooden chair. The intended victim shot the intruder once in his lower body with a gun she grabbed from the safe. It was also noted that the intruder took the victim's gun and cell phone while she was on the phone with 911. The victim sustained a small scratch on her left arm and declined medical aid. The perp was treated for his gunshot wound and taken into custody at the Central Valley Receiving Facility. When asked why he had attacked the victim, he told police, this is an exact quote, "Person did something bad and he just had to know." Police reports reveal that the perp is a cousin of the victim's husband who is allegedly in love with her. This guy is in love with his wife, his cousin's husband's wife. Prior to the June 5th incident, the victim filed a restraining order against the intruder after he allegedly harassed her in front of her 5 children, niece, and family friends. Several children were in the home at the time of this incident. Asked why she never served the 33-year-old the restraining order, the woman said that she didn't want to cause problems with her husband's family, who told her that the intruder is crazy and needed medication. The intruder has pled not guilty to first-degree burglary, assault with a deadly weapon, willful cruelty to a child, false imprisonment with violence, and carrying concealed weapon. He's due back in court July 9th. We're making this broadcast on July 4th, so we'll have more on this later on. The initial comment here, there's apparently a mental case, attacks a woman that he thinks he's in love with. The failure to file the restraining order was a mistake, in my opinion. Sometimes these don't help, but they do establish evidence of prior problems. This appears to be a valid shooting in most any jurisdiction. That being said, we're in California. Mr. Green.
If this case is in San Francisco County and Los Angeles County, and I was the prosecutor, I'd be filing charges against the woman. Because for probably assault with a deadly weapon, discharge of a firearm in an occupied structure. Well, why isn't it self-defense? She knew this perpetrator. She had a restraining order filed but not served. She got the firearm out of the safe, which showed she had the presence of mind. And so what happens with the fear of great bodily injury or death, other than we've got, a rather bizarre scenario where you've got a sledgehammer and a wooden chair, and she refused medical treatment. All of this is going to present a situation where I think in Los Angeles County and San Francisco, this woman is facing the distinct possibility of charges. Why? For the reasons I just stated. File your restraining order. Have the firearm not locked in a safe. But see, that's the problem. If you're in San Francisco, there was that law a few years ago which required you to store a firearm in a safe in your own home, even though it was for self-defense. So, moral of the story, do some training, keep the firearm out of the safe, especially when you got 5 children. My take is 50-50 whether she's going to get charged.
This could be a very dicey case. We're going to break 1 second for a commercial. We'll be back in just a moment.
My name is Jerry Creed, and I'm a gun trust attorney. If you want to own an NFA firearm, a gun trust is a great way to own it because it allows multiple people to lawfully possess a firearm instead of just a single individual. I have reviewed lots of gun trusts, and I have found they often don't include the forms you need to bring people on as trustees and remove them as trustees. In addition, a gun trust will save you the cost of probate and avoid probate, and it can protect your executor and family members. There isn't an element of intent in these laws that affect the NFA firearm possession. So it doesn't matter if your wife didn't intend to sell the gun at a garage sale or yard sale, or your daughter didn't intend to drive the car with the silencer in the trunk. A gun trust is a great way to protect your family members and friends and share in the fun and pleasure of owning NFA weapons. If you want a gun trust done right, remember to trust Jerry.
New firearm regulations are boiling over here in Nevada. My resident attorney here, Don Green, has been doing research on this and has some comments on some of our wins and some of our losses in this pro-self-defense and pro-Second Amendment rights fight. Don, I'm going to turn it over to you and charge on.
Thank you. Thanks to a number of concerned citizens, both at gun shows, people who are talking to other people at gun stores. People were meeting at coffee shops all over the state of Nevada, from the Saddle West and Pahrump all the way up to the Pioneer up in White Pine County, all the way up to those little coffee shops in Sparks and Lander County. All of these people need to be congratulated for this this grassroots movement, which has prevented the following. In Nevada, we will not have a good cause requirement for new concealed weapons permits or renewals. That's been part of the big fight in California, especially the Peruta decision back in June of 2016, which went all the way up to the U.S. Supreme Court, which refused to hear that. And that was whether or not the good cause requirement under the California Penal Code was constitutional as a violation of the Second Amendment. The Ninth Circuit, being a very liberal court, said, number one, there is no right to a concealed weapon permit under the Second Amendment. We agree with that because in Nevada, we don't have to worry about that Second Amendment. We have a statute. So the good cause requirement is not the law. Second, the current concealed weapons requirements are unaffected by the 2019 legislation due to effective lobbying. There were some things that were going to be changed and proposed early in this legislative session and promised by Democrats well into 2017 and, of course, as part of the 2018 general election. Next, we're not going to have a magazine ban in Nevada as they do in California. Now, although the California magazine ban is right now under a restraining order, which Judge Benitez in San Diego federal court has kind of held off on his order pending further adjudication by the Ninth Circuit up in San Francisco. So we don't have a magazine ban in Nevada currently. And unless there's something extraordinary, which happens perhaps with cities making their own bans, we're not going to have one anytime soon. Next, we do not have an assault weapon ban in Nevada. So everyone should be very thankful about that, and people got the message out, and a lot of people were saying, well, what can we do? Well, you start talking to people. You call your legislators. Even if it's a Democrat, just call them. They may not listen to you, but the word got out. The fifth point is that we still do not have a statewide gun registration, but there are possibilities that there may be registration now left to municipalities under the anti-preemption law, which would allow municipalities to literally enact ordinances which might affect both the ownership of guns and registration of guns. Next, we don't have any restrictions on ammunition purchases or sales. Now remember, in California, starting this year and starting next year, this is when there are very severely restricted ammunition sales, including, but not limited to, background checks for ammunition purchases in California. Let me repeat, background checks for ammunition purchases in California. So what does that mean? Are people going to come to Nevada or other states like Arizona and purchase their ammunition? Well, it's quite possible. Is the California Highway Patrol going to sit across the border right there in Primm, Nevada and check you out? We don't know. But right now, we don't have that problem in Nevada. What's the bad news? For some people, it's bad news. Other people, it's marginal news. And in this special report, we have to advise you of the following. We have a bump stock ban in Nevada. My response was, who cares? Because the ATF regulation, which started back in December, preempts Nevada law anyway. And the Bureau of Alcohol, Tobacco, and Firearms issued proposed regulation in December of 2018. Now, under the Federal Administrative Procedure Act, under Title V of the Code of Federal Regulations, there must be a 90-day notice and comment period. That period ended in March 2019. The regulation is law. The bump stocks are now illegal because they constitute a National Firearms Act weapon, as making a weapon an automatic weapon, which is kind of ridiculous because they backtrack on what the original configuration, what the original approval for the configuration of bump stocks was back in the Obama administration twice. and those were to assist handicapped or disabled users of weapons. Now, the bump stock ban is subject to legal challenges by the right person. Just because you own a bump stock isn't going to make you the right person. However, there is the issue of the taking. Is now this an illegal taking of property without just compensation? That's the precise argument made by a company in Houston, Texas, about 2 months ago, when that company filed a lawsuit, not in Texas, not in federal court in Texas, but they were smart because they filed a claim against the United States in the United States Court of Federal Claims in Washington, D.C., which sits without a jury and is very well known for siding with the government and going against the government in appropriate cases. So in Nevada, with a lot of people saying, well, it violates my Second Amendment right. Well, there's virtually no possibility of a successful Second Amendment challenge to the bump stock, because the bump stock does not change the ownership of the weapon. It only changes its physical characteristics in assisting the shooter to fire the weapon, which, and Bob has demonstrated this on a number of shows through references in the movies and references in television shows, that weapons can be fired much more rapidly by proper training or by improper training. Now, will there be successful challenges to the bump stock law regulation in Nevada? Well, it's twofold, because even if you win in Nevada, you still have the ATF regulation, which prohibits it, and under the supremacy clause of the federal constitution and federal law, the ATF regulations trumps whatever happens in Nevada. Next, we have the red flag law, and for those of you who have been living on Mars for the past 2 years, a red flag law is where a designated person by statute, a police officer, a therapist, your wife, your friend, your people who live with you, your relatives, say that Mr. X has a real problem, he's acting kind of crazy and nuts, and he's got some guns. And the police come and seize those weapons. Now, this is going to create what I consider to be a tremendous abuse of this law, especially in domestic relations matters where there's an ugly divorce and the wife wants to really get at her husband, because there will be abuse of that law. And as I see it, although the statute sets forth how the judges in this now gun court are going to act, there is an absence of a clear standard for the seizure and a clear standard for the return, because you, concerned citizen, have to prove that you're not crazy or that you are eligible to get those firearms. So those are going to be legal challenges by the right people. Not that guy, not like those guys who say that they're going to hurt themselves during a baseball game because somebody doesn't win the World Series. These people shouldn't have the firearms in the first place. People who are drinking out in the backyard, who say something about how they feel about certain politicians or whatever. You shouldn't have the firearm anyway if you're going to be out being drunk or drinking. The next area is the storage of firearms. Bob's got some takes on that. I think it's a clearly good law, and I testified in April 2019 that it's a good law because it's reasonably related to a rational purpose. If you don't lock up your firearms and your 9-year-old child takes it to school, you should be put in jail. Because there's just something fundamental about that. Did you want to make a comment?
Yeah, I will delve into that one just a bit, because I was involved in a political fight over this, and I had a highly placed Nevada politician tell me, I'll leave his name out so I don't get into all that stuff, but I've heard it from several people. If the child got a hold of the gun, it obviously wasn't safely stored. And I gave him back an example. The child comes in and spends all night sawing the wall off the safe with a blowtorch, or he finds a thermal lance someplace and he cuts into the safe with professional tools, and he gets the gun out, and the politician said if he got the gun out, then it obviously wasn't safely stored. To me, there is a lot of gray area on what is safely stored. Reasonable is reasonable. Yeah, children shouldn't have access to guns, and we've had a lot of tragedies over that. We've had cases where in one case we're all familiar with, the guy murdered his mother and got in her safe and stole guns and went and shot up a nursery school. The mother's estate is being sued because the guns weren't safely stored. They're in a safe. He murdered his mother to get it, and her estate is still being sued over that issue. These are carried out to ridiculous points. My concern is that we'll have unreasonable application of this law, that it could get into the weeds with his comments that, well, if the child got the gun, it obviously wasn't safely stored. There have to be some reasonable standards. That's it.
Good point, Bob. The last point is, and this is the most controversial, I want to set the record straight for those people who are basically uninformed, and that's the background check law in Nevada. It's basically a good idea, and people are saying, well, wait a minute, it's violating my rights. It's not, because it's not a denial of the ownership or the obtaining of a weapon by people who are otherwise authorized to get the weapon. And people say, well, it's the first step in gun confiscation and gun registration. Well, anytime you go to a federal firearms dealer, anywhere in the United States, or you go to a gun show where gun shows are authorized by and to be sold by federal firearms dealers, you have to fill out the Form 4473. And if you look very carefully on that form on pages 2 and 3, you will see that that form contains very specific required information to be placed by the federal firearms licensee as to the serial number of the weapon, its caliber, the barrel length, and other identifying criteria by make and model. And by federal regulation, that federal firearms dealer must keep that form intact for 20 years. So no one can say there's no such thing as a federal database, because there is. So it's not a violation of the Second Amendment or the Nevada Revised Statute or the Constitution. Now, when I testified in February of this year at this law, which had a joint meeting of the Senate Judiciary Committee and the Assembly Judiciary Committee in Nevada, I brought up 3 points. One, like we filed a lawsuit several years ago, that we want to make sure that the background check is free. It is free when the FFL sends it up to the Nevada Department of Public Safety, although you have to pay the federal firearms licensee $20 to $40. There's no sales tax, which is something which was in my lawsuit several years ago. And in Section 6 of the preamble of the new Nevada background check law, it says as follows: we have the right to bear arms in Nevada. Let me repeat. We have the right to bear arms in Nevada. But in keeping with bearing of those arms comes certain responsibilities, and that is to keep firearms out of the hands of domestic abusers, felons, or other disqualified individuals. I wanted to make sure that stayed in that law, and it's very clear. And that is a legislative enactment, and the beginning says, we, the people of the state of Nevada, and the legislatures do declare as follows: we have the right to bear arms. Thank you.
All right. We are, when you hear things like that you may morally disagree with, and there's a lot here you could morally disagree with, we have the ability to change it. It's called voting. This next election coming up, 2020, we will change our state legislature. The federals will change Congress. We will change lots of stuff. I doubt California's going to change, but we can change here in Nevada at least. And the way you prevent these laws from being acted by the majority of voters is to vote. Register and vote. I thank everybody for listening to Fired Up. We'll be back again next week with a little more common story about gun incidents and so forth and so on. Thanks for listening very much. Have a safe 4th of July. Thanks for watching.